Let's come back from the break, please. May I ask if the CDG witnesses have slides such that they would like screen sharing privileges?
No slides for Ms. Marquez or Ms. Cooper.
All right, thank you. Mr. Colclasure, would you like to introduce your witnesses, please?
Yes, thank you, Madam Hearing Officer. My name is Chris Colclasure, and I'll be asking questions of Ms. Lori Marquez, followed by Casey Spall, who will ask questions of Ms. Jill Cooper. Ms. Marquez's written direct testimony is Appendix C to the Commercial Water Group's Notice of Intent to File Direct Testimony. You can also find her curriculum vitae. Ms. Marquez's rebuttal testimony is Appendix C to the group's Notice of Intent to File Rebuttal Testimony, and there's one attachment to her rebuttal. Neither of these documents have been assigned exhibit numbers. Ms. Marquez, do you need to swear in Ms. Marquez before I proceed?
I do, but I don't see her on the screen. There we go. Hello, Ms. Marquez.
Hello.
Hello. Would you please spell your name?
Yes. Lori is Lori, Marcus, Marquez.
All right. And if you raise your right hand, do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead, Mr. Cole.
Thank you. Ms. Marquez, can you tell the board your employer and your position?
Yes, I'm a senior environmental consultant with BAR Engineering.
And what are your duties with BAR?
I manage air permitting and compliance projects for a variety of clients, primarily oil and gas clients across multiple states.
Have you prepared written, direct, and rebuttal testimony in this proceeding?
Yes, I submitted direct testimony regarding equipment monitoring tags and the costs and benefits of the department's initial proposal for EMT tags. I also addressed the emissions profiles for saltwater disposal wells and the differences between SWD wells and upstream operations, and I submitted rebuttal testimony in response to Wild Earth Guardian's proposal to place new limits on the issuance of permits.
Can you summarize your expertise relevant to these topics and the testimony you will provide?
Yeah, I have a bachelor's in electrical engineering from Purdue University and a master's in environmental science from the University of Colorado. I have over 35 years of engineering and environmental experience, with about 23 years of air quality permitting experience, most of which is specific to the oil and gas industry. My primary expertise is in 9 states, but I've worked in many states. I've prepared hundreds, if not more than 1,000 air permit applications for oil and gas facilities, including GCPs, minor source, and major source permitting. I also have experience with environmental databases at the user level, and I've been a part of many compliance evaluations.
If I were to ask you the questions presented in your direct and rebuttal testimony again today, would your answers be the same?
Yes.
Do you adopt your written testimony as your testimony here today?
Yes, I do.
And before I ask Ms. Marquez for a verbal summary, I offer her written, direct, and rebuttal testimony into the record.
Thank you. Let me pause a moment in the event there are objections. Oh, they're admitted. Thank you.
Thank you. And I'm going to ask Ms. Marquez questions to summarize her written testimony as well as move into her rebuttal of the new information that we've heard during the hearing. So Ms. Marquez, do you support the department's position on equipment monitoring tags in their September 16th version of the proposed regulation?
Yes, the department significantly improved Section 112 by deleting the proposed requirement to require the installation and use of equipment monitoring tags from sections 112A3 and A4. Installing tags with unique QR codes or other identifiers would be prohibitively expensive, especially for smaller operators. I agree with the written direct testimony of NMOGA's witness, John Smitherman, that the department's original proposal for an EMT and database requirement would be highly complex and difficult to implement. So I support striking the requirement to use tags.
Thank you. Do you support the department's proposal to allow operators the flexibility to choose a data system that they'll use to comply with Section 112?
Yes, my written direct testimony describes how operators would be impacted under the department's original EMT proposal. One of these impacts was the potential for incompatibility with existing data systems. Section 112A3 now requires operators to develop and implement a database system capable of storing information for each source in a manner consistent with this section. This gives operators flexibility to choose their own database and to work from their existing software. I work with many oil and gas clients. They use a wide variety of data systems to keep electronic records of environmental and air quality data, ranging from highly sophisticated environmental management systems to Excel spreadsheets. I support allowing operators to use their existing data systems and giving them 2 years to make any necessary changes to be consistent with Section 112.
Do you recommend any revisions to the language in 112A3 requiring operators to develop and implement a database system?
Yeah, the term database system could limit operators' flexibility regarding what software they select. For example, some might not consider Excel spreadsheets to be a database, but a spreadsheet could be enough for smaller operators to track all data points required by Section 112. So I recommend replacing the term database system with data system to clarify that spreadsheets are acceptable if they store and retrieve all of the information needed to comply with Section 112. And I did hear Ms. Keene state that NMED will work on a template for small business to use. We welcome the department's efforts to develop a template, but we are uncertain whether NMED is developing an actual software package that operators can use, or if the template would be a list of requirements. So we look forward to working with NMED to facilitate that effort. Regardless, I think the minor language change to data system could facilitate the state's efforts in the event that they establish a spreadsheet template, and it would certainly help small operators to comply with the record-keeping requirements of the rule.
Okay. Turning now to the requirement for an annual compliance certification. Have you reviewed the department's latest proposed revisions to Section 112C3? And to be clear, I'm referring to the department's rebuttal exhibit 23 from September 16th.
Yes.
Did you hear Mr. Smitherman's testimony regarding the annual compliance evaluations?
Yes.
Do you have concerns regarding the department's new proposal?
Yes, we appreciate the department's efforts to decouple the compliance evaluations from asset transfers. However, the current language substantially expands the scope of the rule. Operators would have to conduct annual compliance evaluations, whether or not the operator is transferring the assets. I've performed and managed many compliance evaluations and self-audits for oil and gas facilities. Based on my experience conducting an annual compliance evaluation and certifying compliance for each source subject to Part 50 would impose a substantial burden on operators. The rule applies to a large number of facilities. Some members of the commercial water disposal group operate other facilities and equipment that would be subject to annual compliance evaluations, even though for some types of equipment, such as dehydrators, engines, compressor seals, fugitives, The group did not submit much, if any, testimony on the specific emission standards proposed for that equipment. It's very unusual to conduct an annual compliance evaluation of every source in a county or other geographic area. It is much more common for operators to conduct smaller periodic self-audits. In my professional opinion, the potential benefits of conducting annual compliance evaluations do not justify the cost.
Understood. Did you have an opportunity to hear the department's witness, Mr. Palmer, testify on Wednesday that if operators are complying with the record-keeping requirements of Part 50, the burden of the annual compliance evaluations would be very, very minimal?
Unfortunately, I did not.
Okay. Well, even if you didn't hear him, would you agree that the burden of conducting these annual evaluations would be minimal?
No, compliance evaluations are not small projects. And in fact, environmental consultants like myself earn a sizable share of our income from compliance evaluations.
Do you have any recommendations regarding this rule language?
Section 112C3 should not be adopted in its current form. The parties should be given an opportunity to revise the rule and develop language that accomplishes the department's goals and can be successfully implemented. It sounds like NMOGA may be discussing rule language with the department. I agree that further stakeholder conversations on this issue are needed. I understand that Ms. Cooper is also going to be presenting testimony on this issue. I will allow her to speak and I will be available for questions on the topic as well.
Very good. Did you hear Ms. Keene's testimony this morning regarding calculations of the potential to emit from sources?
Yes, I did.
Is it feasible for operators to have a professional engineer or an in-house engineer certify the calculation of each source's potential to emit?
Not for all operators. Smaller operators have limited, if any, internal environmental staff and rely heavily on environmental professionals to prepare their permit applications. Many of these environmental professionals are not registered professional engineers, and many environmental professionals have bachelor's degrees in science disciplines such as atmospheric science, environmental science, and meteorology. The requirement for a registered PE stamp for every permit application PTE calculation would greatly increase the cost of their permit applications because the PE's time would be an additional cost, and they may charge a premium to review and stamp emission calculations.
Would the engineer certification improve the accuracy of the calculation?
In my opinion, no. The accuracy of the emission calculations depends on the expertise and qualifications of the person performing the calculations. My experience has been that there are many qualified environmental professionals who are not registered professional engineers. Process knowledge and attention to detail are the critical qualities to assure accuracy.
Thank you. One last topic. Did your written testimony address the proposal by Wild Earth Guardians to restrict the issuance of permits to oil and gas facilities?
Yes, my written rebuttal testimony explains how WEG's proposal would conflict with existing permit programs. WEG's proposal is problematic for several reasons. I will flag those reasons briefly now, and I may provide additional testimony on rebuttal after the board hears WEG's verbal testimony. The proposal implies that applicants for an individual minor source permit would have to model the ozone impacts of a single facility. This doesn't work because ozone is a regional pollutant. Single source ozone modeling is not required for minor sources, and technical work performed by EPA demonstrates that individual minor sources in New Mexico do not cause or contribute to ozone NAAQS violations. WEG recently asserted similar claims in a permit appeal. The board rejected WEG's claims in their entirety in January of 2021.
And can I just interrupt to clarify, that permit appeal was in front of this board? Is that correct?
Yes.
Thank you.
WEG's
Did you also have any comments on their proposal about general construction permits?
Yeah, WEG's proposal would call into question the ability of minor sources to register under general construction permits. The board rejected similar claims from WEG in January. The proposal is also unworkable for major source permits in ozone non-attainment areas such as Ana County. The Clean Air Act prescribes a comprehensive and stringent permitting program called non-attainment new source review, which allows the construction of new or modified major sources so long as the operator offsets the increases in emissions by a ratio greater than 1:1. WEG's proposal could block the issuance of permits that are expressly allowed under the non-attainment new source review program. So I agree with the testimony of NMED witness Michael Baca that WEG's proposal is outside the scope of Part 50 because permitting requirements are addressed in separate rule provisions. And I encourage you to reject WEG's proposal.
I have no further questions. Ms. Marquez is available for cross-examination.
Thank you, Ms. Marquez and Mr. Colclasher. Council, please show up on the screen if you have questions of Ms. Marquez. Ms. Katz?
Thank you, Madam Hearing Officer. Hello, Ms. Marquez. I just have one question. Did you hear Ms. Keene's regarding the annual compliance certification? Did you hear Ms. Keene's testimony regarding how compliance with the reporting and monitoring record keeping requirements of the rule should essentially make that piece of it fairly easy, and the discussion with NMOGA's counsel and witness about working with the parties to clarify that language?
If it was that today? I missed a
Yes.
little bit yesterday. Yeah, I heard her testimony today.
Okay. Thank you.
Okay, thank you. Any other questions from the parties for Ms. Marquez? Please share your screen there. No, okay. I'm going to turn to the board for their questions. While I'm doing that, if you're an attendee on this platform and have a question, please reach out through chat. Madam Chair, do you have questions of Ms. Marquez?
Thank you, Madam Hearer. Yeah, I have a couple of questions. Thank you again for your testimony. I appreciate you coming to share your expertise and knowledge. I just wanted to go back to a couple of statements you made during your testimony, just so I can make sure I'm clear. You had mentioned that companies do self-audits every year. Is that correct?
I didn't say every year. Many of my clients have audit programs. A lot of the larger operators that I work with do have a revolving compliance audit program where they are doing multiple facilities every year, but they wouldn't do every asset that they own every year.
Okay. So your concern is that there might be a potential new requirement to do those audits every year. Is that correct?
Yeah, the new language requires every facility in those counties to be audited for this program every year.
Okay. Thank you for that. And then I wanted to go back to your comments about the data systems. So would it be just additional or clarification language in the proposed rules to clarify that spreadsheets could be also data systems?
Yeah, I think using the phrase data system would allow an Excel spreadsheet, which I think would benefit the smaller operators who don't have sophisticated database systems. because an Excel spreadsheet really isn't a database. So it's more of
Okay.
a clarification.
Okay, and that hasn't been provided yet to NMED or language regarding that? Have you provided that to recommendation to NMED yet?
No, I
Oh.
have not.
Right, and then I have one more question. Hold on. Testimony, you had mentioned that in Mr. Baca's testimony regarding Wild Earth Guardians, I think it was related to permitting and different agency permits and different types of permits. Under what would you be able to provide a reference or the rule or regulation that covers the permitting mechanism associated to what Wild Earth Guardian was saying, proposing in terms of permits?
They're proposing modeling, single source modeling.
Right.
Are you looking for the New Mexico permitting?
Yeah, I was just wondering if you had that reference.
Not right in front of me.
Okay, but that would be under would that be under OCC? I mean OCD permitting jurisdiction?
The New Mexico, the NMED permitting, air permitting program.
Okay, all right. I just wanted a reference on that. Well, thank you so much. Those are all my questions.
Okay, thank you.
Thank you, Madam Chair. Vice Chair Trujillo Davis.
Yes, thank you, Ms. Marquez, for taking the time to chat with us today. I just had a couple of questions about your experience working with operators. Have you, in your experience, helped install one of these tracking systems for any of your clients?
Installing, no, I have not.
Okay, that was kind of where my line of questioning was going. So thank you for taking the time to talk with us today.
Sure.
Thank you. Member Cates.
No questions right at the moment, thanks.
All right. Member Bitzer.
No questions, thank you.
Thank you. Member Garcia.
Thank you. Just one clarifying question. I understand that NMOGA is working on some language in that section C3, I think it was 112 C3. So are you going to wait and see what NMOGA and NMED come up with and see if that works for you, or will you all be proposing your own language?
Hopefully it would be a collaborative effort.
Okay, thank you.
And I will just say, I believe that it would be the department's intent for that to be a collaborative effort.
Okay. Member Hunker.
No questions.
Member Duval.
No questions. Thank you. I apologize for my absence. I have teaching responsibilities that I can't get around. So that's why I've been popping in and out. But
All right. Thank you very much. Let's see. Will there be any follow-up, Mr. Kolkleischer?
No more questions, Madam Hearing Officer.
All right. Thank you very much, Ms. Marcus, for your testimony. We'll excuse you for the moment. And I see Jill Cooper on the screen. Ms. Cooper, would you spell your name, please?
Yes, can you hear me all right?
Yes.
Great, thank you. Just let me know if there's any volume issues. Jillcooper.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you.
Hi, this is Casey Spall. I'll be asking Ms. Cooper her questions. Ms. Cooper's written direct testimony is in Appendix C to the Commercial Disposal Group's Notice of Intent to File Direct Testimony. and her CV is attached. And her rebuttal testimony is Appendix C to her notice of intent to file rebuttal testimony. Ms. Cooper, please state your full name, employer, and your position.
Sure, my name is Jill Cooper. I'm a senior principal with Geosyntec Consultants.
And what is your duties at that firm?
I oversee projects related to air quality, climate, water, waste, compliance, sustainability, much of it for the upstream and midstream energy industry.
And have you prepared direct and rebuttal testimony in these proceedings?
Yes, I have.
And which topics have those been on?
I submitted direct testimony regarding 112C on compliance evaluations and Section 126 on produced water management units, and then rebuttal testimony on several of the definitions. Again, Section 112C, Section 123 on storage vessels, and again, Section 126 on produced water management units.
And could you briefly summarize your expertise that's relevant to your testimony in this matter?
Absolutely. I have a JD in environmental law from the University of Colorado. My first role was with the state of Colorado's Air Division, CDPHE. I was their in-house air attorney, where I settled enforcement actions and also led rulemaking processes. And then I moved on to run sustainability and manage the Colorado self-audit program. After leaving CDPHE, I led several environmental health and safety teams with upstream, midstream oil and gas companies, in particular in Encana and Anadarko Petroleum. When working with the upstream, midstream companies, I managed environmental regulatory, compliance, data management, reporting, and the EHS auditing teams and the associated data systems with the audit programs. So I have experience with environmental databases, a certain amount of electronic data field systems, and in overseeing internal compliance and audit teams. I participated in or oversaw hundreds of compliance assessments and audits. My experience involves multiple states, including New Mexico, Colorado, Texas, Utah, North Dakota, Michigan, Wyoming, and various others.
Thank you. And
I'm
do you
sorry,
agree
Ms.
today?
Spall, to interrupt, Ms. Spall, I'm sorry. Ms. Cooper, would you speak more slowly, please?
Yes.
Thank you.
She tries, but
I
she's always in a
try.
hurry. Ms. Cooper, do you today agree with the testimony that you filed in this matter and your direct and rebuttal submissions?
Yes, I do.
And do you adopt that testimony here today?
Yes, I do.
And before I ask Ms. Cooper to summarize her testimony and her position on the current department proposal, I will offer her written direct and rebuttal testimony into the record. I don't believe there are any objections.
Right. Let me pause for the moment. In the event there are objections, hearing none, they're admitted. Thank you.
Thank you. Ms. Cooper, the department proposes to revise Section 112C3 to require each owner and operator to conduct an annual compliance evaluation and prepare an electronic record to certify the compliance status of each source. Please describe the level of effort that would be necessary to conduct this annual compliance evaluation for every source at these facilities.
In my experience in managing audit and compliance programs for upstream and midstream companies, the proposed rule as drafted would pose a significant cost burden and overall burden on operators. It will likely have a diminishing benefit over time to do this on an annual basis. This opinion is based on my experience in managing compliance and audit programs and being involved with numerous compliance evaluations and audits. Compliance assessments to some degree are already conducted within companies. They usually have their own schedule they're following. It is usually done on a regular basis, and certain environmental programs or regulations already have compliance requirements, self-evaluation requirements. In my experience, an annual assessment ends up not really being that economic or practical due to the level of effort it takes. Most companies that I've experienced with either internally or working with as a peer, they usually come up with an audit schedule where a site might be evaluated every 3 years instead of every year. The reason being, it doesn't necessarily always make sense to do that level of rigor and assessment on an annual basis at every site. They may also identify certain sites that do need a higher frequency of assessments. So it can be quite burdensome to annually evaluate compliance of every facility with all of the Part 50 requirements. As a part of such efforts, operators often must hire external consultants and attorneys to evaluate the permits, the regulatory requirements, determine the standards that are applicable to each facility, compile and review the records, and then compare the facility's operational status to the applicable requirements. In addition, this requirement will complicate the ability of a company to manage a voluntary compliance audit program, take advantage of EPA's self-audit privilege law, and be treated as other sectors in New Mexico are currently treated. Based on my personal knowledge, New Mexico doesn't apparently require this of any other sector unless they're subject to a Title V operating permit requirement to do semi-annual compliance evaluations. And there's been discussion on these data systems and advanced data systems. Even if a company has an advanced data system, there can be a cost associated with adding the type of modules we're talking about into those data systems. So I do understand there's been discussions about using spreadsheets, which would be much more flexible and appropriate for many of the operators. So based on the verbal testimony, we think the department intends for the rule to be less burdensome than what the current draft language suggests, and we do look forward to being a part of those discussions.
Thank you, Ms. Cooper. Do you have any other concerns with requiring annual compliance evaluations in Section 112C3?
Yes, I'm concerned that operators will need to certify the compliance status. Use of the word certification in Section 112C3 makes the rule even more burdensome and could expose operators and the certifying official to liability if something is missed. Most facilities are not required to prepare such periodic compliance certifications. This is usually just reserved for Title V, large Title V operating sources. In my opinion, it's not appropriate or necessary to impose an annual compliance certification requirement on minor sources. And again, I don't see any requirement that New Mexico has asked any other source type or sector to meet this type of obligation. In addition, the scope of the proposed requirement is somewhat unclear. It currently doesn't specify whether an operator could conduct the compliance assessment on a records review or desktop paper audit, or whether it might require field visits to every location before a certification can be completed. While paper audits can still be burdensome and time-consuming, it'll be significantly more burdensome if site visits are expected and required. Mr. Smitherman, representing NMOGA, suggested having operators run an annual compliance data report and certify that it is true rather than certifying the compliance status of each facility. We just heard that suggestion a few minutes ago, and I need to confer with the commercial water disposal group. But I do feel this idea could be a reasonable starting point for revising that part of the regulation. The proposed March 1 deadline is challenging, having led many air teams through my career and now being a consultant. Operators and consultants have a lot of reporting requirements in the first quarter of the year. Greenhouse gas reporting to EPA, annual, triannual emission inventories, Precursor Title II, and other federal reporting requirements can all come in at the same time. So this rule would impose significant additional burdens during already hectic time of the year, which means they will be hiring consultants and lawyers to support, and they may even be difficult to meet the expectations with the external support. Finally, my last point is the board already has rules on the books that provide visibility into sources compliant status. Operators are required to submit excess emission reports under section 127.7, section 20.2.7.110. And the annual compliance evaluations would at least be partially duplicative of these EERs, excess emission reports. And they also may duplicate any Title V reporting requirements that are there. For these reasons, I agree there's a need for further discussions to revise the language of this section of the proposed rule. Thank you.
Thank you, Ms. Cooper. Ms. Cooper is now available for cross-examination.
Thank you very much, Ms. Schwal and Ms. Cooper. Ms. Katz, I see you on the screen. Do you have questions?
Thank you. Hello, Ms. Cooper. I just have a couple questions. So do you, you don't see the word audit in the language regarding the annual compliance certification, is that correct?
That is correct.
Okay, thank you. And did the commercial disposal group, have they prepared any suggested revisions to those provisions that would address your the concerns you've outlined, or did their counsel contact NMED's counsel to discuss what the intent of that provision was?
I think I would like to defer to counsel for the counsel question.
Okay, I guess I should say, do you know if?
Is Casey able to respond? Ms. Schwal able to respond to the legal counsel question?
You can just say whether you know if or not.
Okay. I do not know that we've proposed anything specific to NMED yet on revisions to this section.
Okay, thank you very much. That's all I have.
Thank you. Is there anyone else who would like to turn on their screen among the parties? Seeing no new screens, I'll turn now to the board for their questions. If you're on the platform as an attendee and you have a question, please reach out through the chat. Madam Chair, do you have questions of Ms. Cooper? You seem to have frozen.
Thank you, Madam Hearing Officer. I do have a few questions.
Her audio is cutting up, cutting out.
Madam Chair, I'm sorry, you're freezing
Again,
and the audio's cutting out.
Today,
Can we stop
am I
your
frozen?
video? Stop your video. There you go.
Can you hear?
I'm sorry, that didn't really help. I'm going to go to the other board members and hopefully we can get your connection strengthened.
Go ahead and yeah.
Okay. She said go ahead, and I think she hopes the other board members address her topics. Vice Chair Trujillo Davis, do you have questions of Ms. Cooper?
I don't have any questions at this time. Thank you, Ms. Cooper.
All right, thank you. Member Cates?
No questions right now.
Thank you. Member Bitzer?
I really don't have any questions, but I feel like maybe I should stall until Chair Suwina's bandwidth improves. So, hey, real quick, have we seen or heard from counsel for the board from the Attorney General's office? I want to do a well check real quick.
Oh, you know
Uh,
what? Member Bitzer, Ms.
Laura,
Soloria,
are you out there?
Ms.
What's
Soloria
that?
has been on the platform for uh, at least virtually the whole hearing, if not all of it, but she hasn't
And I
spoken up.
and I figured as much, but there's so many other lawyers in the room. It's sort of in the virtual room that she's like, they got this. Maybe I don't know. There's Suina. So no, I have no questions.
All right, thank you. And there you did. You stalled long enough to bring Madam Chair back. Madam Chair?
Thank you so much. Is this better?
Definitely.
Great. I'm going to turn off my video just in case. All right. Thank you, Ms. Cooper, and thank you, Madam Hearing Officer and Member Bitzer. I appreciate the stalling for me. I just wanted some clarification. Again, thank you for your testimony. You had mentioned that, again, some of the companies you work with do have a voluntary kind of program, monitoring program. Is that program done out of, I guess it's a voluntary program, but in your opinion, why would a company do that?
All of a sudden, I can't see anybody, and I couldn't see myself either.
Casey, I think you may want to mute yourself.
Yeah.
So
They
very
said,
good
"Why aren't you
question. And
they said I
I'm
could.
sorry, I think, can someone mute Casey? Okay, she's muted. Thank you. Very good question. And companies may develop internal compliance assessment programs as part of a regular compliance regulatory program. And due to this differences between sizes of companies, types of operations, it could be a different level of detail they go into and a different frequency, but they often do it as a way to confirm compliance status of their own and manage risk.
Thank you for that answer. And just as a follow-up question, so in these voluntary programs or initiatives that a company may utilize, do they have elaborate databases, or do some of those, in your experience, or do they also use a spreadsheet format or another way of tracking and documenting?
Yeah, the larger companies will have a data system. More of the companies I work with as a consultant will be using spreadsheets and sometimes even other types of filing systems, can even be hard copy sometimes, but they tend not to have the more complicated data systems.
And so I was just wondering, with that additional tracking or voluntary compliance system, is there also a cost benefit for companies that do that?
I have never been involved in developing a cost benefit analysis for compliance assessments. So I don't know if there's a cost benefit associated with initiating a compliance program. It's more based on the risk management side.
Okay, so in terms of risk management and maybe associated costs, do you, in your profession and in your experience, do you see that, and this may be very obvious, but do you see that the larger companies have the ability to implement the voluntary programs because of the cost issue, or because I think you have mentioned it's an additional cost burden, is what I'm getting at.
Yeah, it is an additional cost. So when I had an audit team, it was a large company and we had a few people dedicated, but that was a large company, a good sized company, and we had maybe 2.5 people doing dedicated to the audit program. And that was annually an expense that we incurred. It would be, in my opinion, it would be much more difficult for smaller operators to be able to maintain that level of staff, because they're not only auditing for air quality, they're auditing for other topical requirements and safety and other things. So it would be a burden for them to have somebody dedicated to air auditing full-time on an audit team. I've not had a full-time air auditor in my past roles. We had to pull in people from the existing air team or consultants to do that work.
Thank you for those responses. I appreciate them. I want to go to, I think, some of the last topics you covered, and one was you had mentioned that the board already has rules on the books regarding the excess emission reports. In your experience and working in the industry, do companies are they comprehensive and I guess forthcoming in those reports? I mean,
In my experience,
Yeah.
I'm sorry, did you have a follow-up?
no, go ahead.
Oh, okay. In my experience, companies that I have worked for and I work with as a consultant do take the existing environmental requirements like excess emission reports very seriously, as well as things like Title V semi-annual reports. And they need to do a certain amount of rigorous evaluation to ensure it's accurate or to evaluate its accuracy before they can sign or send anything to the state. So in my experience, they take it seriously.
And in that process of submitting excess emission reports, in the proposed rules, would similar data and information be required or is being proposed to be required as would be in the annual inspection?
Not knowing what the detailed final requirements are going to look like, I would assume that at a minimum, they're asking for excess emission data be provided. If you exceeded an emission limit that you report it. That's an assumption I'm making based on how the draft regulation looks and some of the testimony we heard today. So I would assume there will be a certain amount of overlap between the excess emission reports and the compliance evaluations that are being asked for here.
Thank you for that response. And just two more follow-up. So in your experience in terms of compliance, once you have, say, a database or some sort of data management system, whether it's a spreadsheet, is the cost of getting that up and running more burdensome, say, the first few months, year, than it is to maintain that over time?
Really good question. And so I've been involved with companies, including the state of Colorado, creating these kind of data systems. It can take years to get them up and running. If you're starting with a system that's a spreadsheet-based system first, we would normally have a 2-year process to select, establish, move data into a system, set up the modules you need, and then train people on how to use them, because you need to train a number of people in different roles on how to input data. I imagine for an air-only system, you may be able to shorten that window a little bit, but it actually is complex to roll these systems out, and it is expensive up front. What I always got to tell my leadership when we came to budget is that even once the system is up, I had to have dedicated staff to manage it. Things don't work, they need to be changed, you need to go make sure people know how to use the system. So I always ended up having 1 or 2 people dedicated to managing the system, pulling out data, inserting data when you needed to, fixing problems. And it wasn't only my IT group. I had to have dedicated EHS data people. It's a really good question. Everyone thinks the whole cost is in the setup. It's longer and more expensive than most people may think, but the ongoing recurring costs of managing it is another expense that most people don't notice. So thank you for asking that.
So I was wondering if you already have a voluntary program within a company set up, would the transition to a required reporting be less? And I apologize if the answer is going to be obvious, but less than if somebody did not have that system up and running?
Yes, it will be a little easier for companies that already have compliance management systems. And as I indicated in my testimony that, for example, we would not audit the same location every year unless there was a specific reason to. You know, that we may be auditing for process safety one year and air quality another, but typically we would not audit for the same requirement at every facility every year. So even companies that have a program set up, if the frequency is going from something they had flexibility with to a mandatory annual, it will increase costs for those companies. And the answer to your question is yes, if you have nothing, it is going to cost you more than if you have something set up. It will cost them less.
Thank you, Ms. Cooper. Appreciate your responses. Thank you.
Thank you
That's
very
all for now.
much.
Thank
Appreciate
you.
your questions.
Member Duvall?
No questions.
Thank you. Member Garcia?
No questions.
Thank you. Member Hunker?
Yes, Ms. Cooper, I did have a couple questions on the annual compliance evaluation comments you made. You talked about the burdensome nature. Do you have any sort of an estimate of dollars or workload on you know, on some type of a facility basis to give us a better understanding beyond burdensome?
Very good question. And I have not done that type of economic analysis. Perhaps when we sit down with an MED and have that discussion, we might be able to come up with something. I only have my past experience with companies the size of Anadarko and Encana and how many people I had dedicated to it.
Yeah.
But I never went down to a dollar per facility basis. We had 10,000 locations across the world. And so I never narrowed it down to a cost. It's a good question. I wish I had an answer.
Understand. And I think in follow-up discussions with NMED, they'd appreciate any sort of insight you can give on what elements of it really make it burdensome in your mind. And then one thing you said kind of stood out to me, and that was potentially an operator having to get an attorney or a consultant to explain the requirements to them. Now, I can see if you have a complex Title V permit or something like that, where that might be necessary for such a compliance certification, but it seems like these requirements that an operator should be working with on a daily or monthly basis to make sure they're in compliance wouldn't require any elaborate steps such as that, especially for smaller operators. What do you think otherwise?
Good thing to pick up on. I'm glad you did. So having run, like when I was running the company's audit program, we would on a regular basis pull legal counsel in for confidentiality until we saw, you know, to work through the process and work through compliance questions. Even though regulations may seem very clear on their face, when you interconnect Part 50 with new source performance standards, with other state requirements, with greenhouse gas, other requirements, you don't always notice when you're writing the rules. And I've been in the seat this amazing air team is in right now at the state, and you haven't always lined up how these rules connect. And so if the EPA changes their NSPS Quado A, we call it, and modifies it to some regards, the companies will probably need to pull in experienced legal counsel to figure out how it meets up with NMED. I would even argue they would want to do it right now with the existing NSPSs, with existing permits they already have and general conditions and permits that they have. Sometimes it even may pull in a different media, like a water group or a waste group, because you may have something in one permit that requires something and another one requires something else. So what I found, even though I'm a non-practicing attorney, I would almost always pull in either internal environmental counsel if I had one, but most of these companies probably will not, or we'll go to external specialists to help us interpret it maybe even go meet with the state from time to time and make sure we understand it right. And honestly, people will read words differently and things differently. So also every so often, we would ask legal counsel to review our audit questions and our applicability to make sure we didn't miss something. So it may not be for every single audit, but if I'm obligated to do all of my sites once a year under this rule, I'm likely going to have an attorney involved because I want them to help us interpret questions if I'm going to do every single site every year. It may not be they're involved in every single location, but they're going to be involved in the whole process.
Okay, thank you. No other questions. Thanks.
Thank you for that question.
Thank you. We'll go back to the vice chair and then member Garcia.
Thank you, Ms. Cooper. I have to say, your testimony really landed for me because in my experience, lines up exactly with the way you described an audit occurring. And it just lines up with my experience. And each year that we would do an audit, we take a week out of the year and the entire staff was dedicated to an audit. And at the end of that week, we would sit down and say, you know, how could we do this better next year? Because it always seemed to be a little bit of a fumble in one area, and then the next year was a different area. So in all the years that you've been conducting these audits, I'm curious if you have any recommendations that really stick out in your mind that would be helpful for us to consider.
That's a really good question, and thank you for asking that. I'm glad what I'm saying is having some value. And yes, typically when we would launch an EHS audit or a process safety audit, it would be a 5-day, 1-day travel, get out there, 4 days intensive. Air was one of the topics. If we did an air only audit, again, it was usually 2 or 3 days and you hit maybe 3 or 4 sites. So it actually takes more time than you think. So I think my recommendation would be plan well in advance, pilot a few self-assessments. And I know that the division, I used the word audit and I shouldn't have, I know it was not it, it's just how I think about it. But plan, evaluate, pilot a few if you haven't really done these before. Again, pull legal in, either internal or external legal counsel, hold it under attorney-client privilege. Don't be afraid to ask the question that something doesn't make sense. Because if you wait till the end and you've gone through all this process of evaluating compliance, and then what the question you wish you asked in the beginning applies to 100 locations, you're going to wish you asked it early on. And then if you find potential compliance issues, never call them a non-compliance because only the state can do that. But secondly, try to evaluate the true root cause. A really good compliance evaluation program, the ones that I learned about at the state of Colorado and then worked on with companies, they wouldn't stop at what you think the root cause of the compliance issue is or the potential compliance issue. You ask 3 questions more to figure out why something isn't happening. Sometimes it was field people trying to not cause a safety issue. And so they did something that might have gotten in the way of an air or water quality requirement, but it's because in all of their safety training that they've had in the field for decades, it was going to put someone at risk. And so one of the most important and most meaningful things, because we all in the oil industry want to send everyone home without any life-changing events, it's number one, is don't forget to ask those last couple questions, because sometimes the operation teams are smarter than we give them credit for, and they actually have a good reason why they were doing something. It may not be in alignment with what we think is needed for air. And I would ask the state to really listen to that if it comes up that way. I've had those discussions with federal, state agencies, onshore and offshore, about when a rule might be compromising someone's safety. So if there was one takeaway, is don't be afraid to ask those questions and really dig into why something isn't going well. Thank you for asking that.
Thank you for your testimony, and I think Member Sweeney asked a lot of the questions I wanted to ask, and Member Honker really had some great questioning there, so thank you both for helping me out there.
Member Garcia.
Your testimony, Ms. Cooper. I don't know which would, can you hear me? Thank you for your testimony, Ms. Cooper. I don't know which would be harder, to be an attorney for one of these companies or environmental consultant. They're both difficult jobs, I'm sure. So my question though involves, and it might be Ms. Katz that might end up answering this, but you and the previous witness mentioned the burden to small operators regarding some of these record-keeping requirements. And I'm wondering, what is your, what do you consider a small operator? And the reason I'm asking this is, and this is the part Ms. Katz will probably answer, I don't know if this comes under the small business exemption or not, this section, or how that's impacted by the small business exemption. But anyway, I would be interested in your opinion of what a small operator is and how they would be burdened more by
That's
this.
a really good question. They're obvious, and I don't want to upset any of the larger operators that are on the call, but the integrated companies that have upstream, midstream, downstream, sell to the market, that's not a smaller operator. And then there's, I wasn't thinking the definition of the small business assistance program. I do know that. I used to run Colorado's when I had that self-audit and other things. I was thinking of more generic, I think my co-testimony person was as well, Lori. It was more like there's the integrated, there's the mid-sized companies, of which I worked for two of them, Anadarko and Encana. And then there's the group that's probably one step below that. I don't think they would qualify as small businesses, but they're just below that middle level sets of company. And we do use that term loosely, so I appreciate you asking. I don't mean only the small business defined companies. I don't know if Ms. Katz wanted to say anything with that or not, but.
Thank you.
Thank you. Any other questions from the board? No. Ms. Schwal, will there be any redirect?
No, thank you.
All right. Well, thank you very much, Ms. Cooper, for your testimony. We can excuse.
Thank you. It's an honor and pleasure to be here. Thank you for all your everybody's work, the board and the division. You guys are doing an amazing job. Thank you.
Thank you. So I believe we return to Mr. Nichols. Is that true?
Yes, Madam Hearing Officer. And then I just want to, if I can remind the board that the department will be coming back on for the rebuttal for all of this testimony, so that you can just remember that the department, there will be department witnesses coming back around to address all of this.
All right, thank you, Ms. Katz. Mr. Nykiel, I see you on screen, and Mr. Nichols, I see you on screen as well. You're still under oath. Whenever you're ready, Mr. Nykiel.
Thank you very much, Madam Hearing Officer. Mr. Nichols, good afternoon. You've testified to your experience already, and you have adopted your direct testimony that you submitted as your testimony today. And so we have two proposals to discuss in this topic, and our relevant exhibits for the board would be Wild Earth Guardians Exhibit 1, which is our red line, and then Wild Earth Guardians Exhibit 3, which is Mr. Nichols' direct technical testimony explaining those, the last two of our proposals. So to begin with, Mr. Nichols, would you briefly just summarize what our second proposal around permit denial does, and just summarize that for the board?
Yes, and thank you, and good afternoon. Madam Hearing Officer, Madam Chair, members of the board. And just so I'm clear, you want me to speak to our proposed revision or red line to the general provision related to permitting?
That's right. Yes.
Okay. So what we have proposed is we're kind of taken a page from New Mexico's leadership around the issue of addressing ozone pollution. As this board knows, there is a statutory requirement that if ozone concentrations get within 95% of the ambient air quality standards, that a plan needs to be developed to reduce those emissions or reduce emissions such that ozone concentrations are kept below 95% of the ambient air quality standard. And that's a very powerful statutory provision. It's a leading statutory provision. We don't see this in other states' statutes. And so New Mexico has already taken that big step forward to identify when action is needed to address ozone pollution. Flowing from that, what we have proposed is a regulatory provision that would ensure consistency in adhering to that statutory requirement around the permitting process. In an effort to ensure that emissions are properly kept in check. And what we have done is we have almost verbatim taken language from the current Environment Department rules, which prohibit the department from approving permits that would cause or contribute to violations of ambient air quality standards, and propose to apply that in the context of regulating the oil and gas sector around ozone pollution. And the specific language that we have put forward is that if it's determined that a stationary source would cause or contribute to concentrations of ozone that exceed 95% of the ambient air quality standards, then those permits must be denied. And that ensures that the permitting activities that are undertaken by the department are harmonizing with the efforts to ensure effective emission controls and ensure an effective plan to reduce ozone is implemented.
And Mr. Nichols, we've heard a lot today about different compliance deadlines that are proposed in the rules. Could you describe what the benefit of our proposal would be in regards to, as these rules become effective over time, what would the benefit of our proposal be?
Well, I think it would be very complementary to what the department has put forward already, which would tighten up regulation and oversight of existing sources. And this ensures that as new sources are proposed and subject to review by the department, that an appropriate consideration of the impacts to ozone ambient air quality standards is undertaken. And ultimately, that there's caution exercised, that the department doesn't inadvertently worsen the ozone problem in a manner that may be inconsistent with the current statutory requirement.
And just along that line, right, it won't be the case that if the department's rules are adopted by the board, that all of the emission controls will immediately apply. Is that right?
Sure, there are compliance timeframes, yes.
Right. Just a few brief rebuttal questions for you. Mr. Baca testified in rebuttal that our proposal isn't within the scope of this rulemaking. Do you agree with that?
No, I don't. I believe that our proposal would achieve emission reductions within the oil and gas sector. Cautionary reductions likely. It's not a given that permits are going to be denied, but if by chance a stationary source is deemed to cause and contribute to concentrations that are dangerous, as acknowledged by the statute, then it would compel a degree of forbearance, I guess, in terms of approving these permits, and that'll go a long way to ensuring ozone concentrations are kept in check.
Mr. Baca also testified in rebuttal that self-reporting, going to move on to Sir rebuttal for Ms. Marquez. Ms. Marquez testified on rebuttal that there is no, that a problem with Guardian's proposal is that there's no process that exists to identify areas where the ozone concentrations exceed 95% of the NAAQS. There's no process to draw boundaries and establish effective dates. But isn't that all laid out in section 20.2.50.2 of the proposed rule?
Yes, I believe it is. Yes. I mean, the department has already taken a step to identify the areas of concern and identify where monitors are within 95% of the ambient air quality standards, and presumably, you know, their judgment will continue to be exercised in the context of what we've proposed.
Okay. Ms. Marquez also testified on rebuttal that Guardian's proposal would disrupt Congress's carefully crafted permitting program by setting a lower threshold for the cause or contribute demonstration. Do you agree with that?
I don't agree that it would be disruptive. I believe that it is perhaps in some regards more bold than where the federal Clean Air Act requirements are at, and it's reflective of the fact that New Mexico is a bold state. It's already demonstrated that by adopting a statutory requirement to address ozone concentrations before they violate ambient air quality standards.
And New Mexico statute permits the state to propose rules that are beyond the federal requirements.
Yes.
Lastly, on this rebuttal, Ms. Marquez also testified in her rebuttal that she wasn't, that this was unprecedented, this proposal. Do you agree with that, or think that that is of import?
It's unprecedented in that it's not in the current rules. So yes, it's the first of its kind, but we feel like that's a good thing, and it's worth giving consideration to. I would just add that in terms of you know, what it would impose on the department, I don't believe it would impose any modeling requirements or any kind of you know, added procedure that the department doesn't already undertake. The department already reviews permit applications and makes determinations as to whether or not they will cause or contribute to violations of ambient air quality standards. And this simply adds a complementary standard that the department should also be mindful when stationary sources may contribute to concentrations within 95% of the NAAQS. And I don't believe that will require modeling. The department has been very good about coming up with efficient and effective means of assessing impacts to ambient air quality standards.
Okay, thanks, Mr. Nichols. I'm going to turn us to our third proposal around reporting. Would you briefly summarize this proposal for the board?
Yeah, thank you. What we have proposed is the topic that has been coming up a fair amount during this hearing, and it's a requirement that certain reports or certain monitoring data be reported to the Environment Department. And that's simply to foster a higher degree of transparency around the implementation and oversight of the proposed regulations. What we have proposed is that reports or monitoring events that document deviations to the proposed regulations, that they be reported on a semi-annual basis. And that where the emissions are in excess of like emission standards or limitations, that they be reported consistent with the department's excess emission reporting rules, which are under 20.2.7 NMAC. And I will say that where we're coming from on this is that we find air quality data that is within or in the possession of the department to be incredibly valuable for understanding how air quality is being impacted, how it's being regulated. and understanding whether or not certain sources are operating in compliance and whether certain sources need to be doing better. And while we appreciate the department exercising its judgment as an air quality regulatory agency, we strongly believe the public has a very important role to play in being watchdogs and being apprised and informed about how the air they breathe is affected by sources of air pollution. So what we propose is a means to try to accomplish that. We're not suggesting that every monitoring report that's gathered and everything that companies are required to record be submitted to the Environment Department, but simply that deviations, for example, deviations from work practice standards or emission limits, that those monitoring events be reported to the department so that the public can then have access to that information. Information submitted to the department is made available through information requests, whether formal or informal. And I think that's a very important means of demonstrating proof of concept around these rules as they're implemented. It certainly would foster a higher degree of trust and belief that these rules are going to accomplish everything that they claim to accomplish.
And is that sort of reporting common in air pollution control rules generally?
Yeah, it is. We see reporting requirements be established in regulations. For example, in Colorado, there are many provisions of the state's oil and gas air quality regulations that require reporting. We are cognizant that reporting can't become too burdensome for the agency and certainly should accomplish an end. And that's why we really tried to stay laser focused on, hey, just when there are emission exceedances or deviations from the rules, that's when the information should be reported. So we absolutely don't want the department to be inundated with reports that simply say everything is fine. We want them to be provided with reports that say, hey, wait a minute, maybe things need to be assessed here and maybe some changes need to be made.
Okay. And we've already heard today generally how the annual compliance report and the CDRs as proposed work under the rules. Do you have any concerns about the department's discretion in deciding whether or not to request those reports? And well, I'll let you start there.
Certainly, I believe the department will exercise discretion to request those reports at times, but perhaps not necessarily in response to public concerns, and perhaps not when there may be more of a public need for greater awareness. There is no process, for example, for me to contact the department and say, hey, can you please request the compliance reports? And to have any certainty that the department will say, yes, we will do that. That would be more comforting if there was some kind of process to that effect. And it's not that we believe the department will purposely try to stick its head in the sand on seeking these reports. They are watching these facilities to some degree. They have resource limitations, obviously. And we've heard that a lot during this hearing. So we simply want to propose a provision that has certainty there, that as well-intentioned as the department is, that the data will still be given to them and still be available for people to become aware of it and to be informed about it.
And just following on that, do you think there could be equity concerns in how that discretion is used for different communities, given the lack of process?
Well, given a lack of process and just resource constraints, I mean, seems like the public can be a partner with the department in analyzing data, assessing data, and being able to do their part as members of communities to drive effective air quality regulation. And that's really the important thing here is this is not, you know, in the Federal Clean Air Act and the way the EPA regulates, a lot of data has to be made available to the public to ensure the enforceability of those requirements. And here, citizens obviously can't sue to enforce state rules. So there's no, you know, expectation or intention that that will happen but it will enable them to, for example, getting deviation reports, sharing them with community leaders, with elected officials, making sure that there's awareness and understanding of what's going on that transcends the department's world. So I think it will do a lot to address equity. It will do a lot to empower people, and again, do a lot to reassure people that these rules are going to work the way they're intended.
Thank you. I just have a couple more final questions for you before we end with a few rebuttal questions on this proposal. Do you believe that the department's proposal is enough to solve New Mexico's ozone problem?
My apologies, I have a fire truck outside. I have high hopes. We have high hopes, and certainly these rules will be a big step forward. But I think complementing them with some targeted revisions, including a reporting provision, would go a long way to helping us and many members of the public, again, feel reassured that they will work out the way they're intended.
Okay. And if the current ozone attainment initiative does not result in ozone pollution levels dropping below the federal standards, what are some of the potential consequences to the state?
Well, this has been brought up. I mean, the consequences are potential non-attainment designations and the more stringent clean air regulatory oversight that goes along with those kinds of designations, and the restrictions that those designations impose on air pollutant emitting activities. We believe a non-attainment designation can be a very powerful tool for driving action around clean air. And we don't view it as necessarily a bad thing, but certainly there are consequences. And just from a health standpoint, avoiding a non-attainment designation means you're doing good by people. You're keeping emissions in check. And so that's really the goal that we want to see achieved here. And so, yeah, I mean, public health, absolutely. If we can't protect it effectively, then it's not good for New Mexico.
Okay, thank you. And just a few rebuttal questions on this proposal. Mr. Baca testified that self-reporting of the deviation doesn't ensure that the deviation is corrected. Is that, do you agree with that, or do you think that that is a legitimate point?
I don't agree with that. I don't know what the basis is for that. The department already requires a fair amount of self-reporting with the aim of driving compliance. So current reporting structures, for example, the excess emission reporting requirements under 20.2.7 NMAC, they already require many sources to report excess emissions. And the reason is because the department wants to keep tabs on those excess emissions and to work to correct them if needed. And I see the same concept playing out in our proposal here, where deviations can be very informative and help drive a heightened degree of compliance.
And Mr. Baca also testified that reporting violations of the rule wouldn't provide pertinent health information to the public. I think you responded to that a bit, but could you just put a finer point on it?
I don't understand that. I mean, this is all about regulating air pollution to protect public health. If the public can better understand how air quality is being impacted in the context of potential deviations, that seems to have very direct relevance to health and safety and concern for the environment.
Okay. Thank you, Mr. Nichols. Those are all the questions I have for you at the moment, and would offer him for cross-examination.
Thank you very much, Mr. Nykiel and Mr. Nichols. Let me ask the parties to turn on their screen if they have a question. Mr. Nichols. Oh, I see Mr. Colclasher, and then Mr. Rose, and then Ms. Sheehan. Mr. Colclasher.
Yes, thank you, Madam Chair. I do have some questions. Mr. Nichols, regarding your proposal to add a new section 112A11, requiring the department to deny applications for permits in certain circumstances, did you provide any estimate of the emission benefits that your proposal might achieve?
I'm not sure I'm understanding the question.
I'm asking whether you, in your written testimony, provided any estimates of what emission benefits might be achieved by your proposal to constrain permits.
Well, if implemented as we've intended and proposed here, then it will prevent sources of air pollution from being constructed or permitted that would cause or contribute to ozone concentrations within 95% of the NAAQS. So presumably it would prevent those emissions.
So you're presuming it would prevent emissions, but did you provide any estimate of what emissions might be avoided?
I don't know. I mean, it all depends on what's being proposed as far as a new source of air pollution and what's subject to consideration under the permitting process at hand.
Yeah, I'm just asking what was in your written testimony. Did you provide any estimate?
I'm not sure. I mean, there's nothing I guess I don't see anything to estimate right now. It's simply setting or proposing a threshold that would prevent certain sources of air pollution from being constructed if the ozone concentrations that they would cause or contribute to would exceed 95% of the ambient air quality standards.
Did your written testimony evaluate how your proposal would impact the existing process for evaluating permit applications?
I'm not sure what you mean by impact the existing process.
Well, you're proposing a requirement to deny certain permit applications in certain cases. And are you aware that there is already an existing process for evaluating permit applications?
Yes, I'm aware that there's a process.
Did you evaluate how this proposal might change that process?
Well, I think it would add a complementary standard for the department to review. They already assess whether sources will cause or contribute to violations of ambient air quality standards. And this is simply add another layer to that in the context of oil and gas permitting, and of course the statutory requirement around ozone being limited to less than 95% of the ambient air quality standards.
And what I'm getting at is whether you looked at sort of the implementation of your proposal and how it would affect the divisions of the department's workload.
I haven't assessed how it would affect their workload, no.
You stated on your, sorry, were you finished or did you have more to say?
Yeah, I'm finished. Yeah, thank you.
You stated on your direct testimony that you did not think this would require permit applicants to submit modeling. Did I hear that correctly?
Yes.
Are you aware that Wild Earth Guardians filed an administrative appeal with the board in 2020, challenging the issuance of an individual permit that allegedly would have caused or contributed to violations of the NAAQS on the basis that the department did not evaluate the impacts of that permit?
That was a part of the appeal, yes, but there was kind of the initial issue that we raised, which is that all the best available information already suggested that sources that were under, that were under appeal at the time would contribute to violations of the ambient air quality standards.
Do you know whether Wild Earth Guardians asserted in that appeal that the applicant or the department should have modeled the ambient impacts of that facility?
I don't recall that being an argument that modeling should have been prepared. The department asserted it would have to do modeling, and we provided numerous sources of information indicating that that wasn't necessarily the case. But that appeal's been resolved. This board resolved that, and this is, I mean, that's where we're at.
And how did the board resolve that appeal?
Well, the board denied our appeals.
Are you aware that Wild Earth Guardians also challenged certain general construction permit registrations on the basis that they should not have been issued in an area where ozone monitoring concentrations exceeded the ozone NAAQS?
Yes.
And did the board also reject that claim?
The board denied our petitions for review on the basis that the department adequately demonstrated that it addressed the impacts of those facilities to the ozone ambient air quality standards.
So you agree that the board denied that claim? Is that what I'm hearing?
The board upheld the department's analysis of how those facilities affected ambient ozone concentrations.
Okay. In your proposed section 112A11, are you proposing language that would constrain the department's ability to issue general construction permits in some situations?
I don't, so can I ask for some clarity? When you say approve general permits, you mean approve the overarching general permit or the registrations for general permits?
The registration. Your language, I believe, says that the board must deny general construction permit registrations if the source would cause or contribute to an exceedance of 95% of the ozone max.
Yes, similar to current standard, which is a source can be subject to general permit registration if it would cause or contribute to violations of ozone ambient air quality standards.
Do you have an estimate of how many general construction permit registrations the department processes in a given month, roughly
A
speaking?
lot. I have no firm estimate. I know it's a lot.
If the board were unable to approve GCP registrations for those facilities, would that impact the board's workload?
The board's workload or the department's?
Excuse me, the department's workload.
I'm not sure.
Is it fair to say that if they had to evaluate whether each GCP registration would cause or contribute to an exceedance of 95% of the max standard, that it would increase the department's workload?
I believe the department has shown itself to be very competent when it comes to efficiently assessing the impacts of sources subject to general permits to ambient air quality standards. And if I remember right, a core thrust of their response to our appeal last year was that minor sources are presumed to not contribute to ozone concentrations in excess of the ambient air quality standards for ozone. We may take issue with that, but operating under their current framework, it would seem that they would not have to deny general permits and that it likely would have a minimal impact, if any, on their workload.
I didn't follow that response. Are you testifying that the board would continue to approve GCP registrations under your new rule?
I don't see any reason why not.
Okay, I will leave it there and just turn to the next, slightly different topic. You testified on direct that there are other jurisdictions that have provisions requiring operators to submit reports of deviations. Do you recall that?
Yes.
And I believe you identified Colorado as a jurisdiction where operators must submit deviation reports.
The type of reporting varies, but there is a level of reporting within the state's set of regulations addressing the oil and gas sector.
Is it your testimony that there is a provision similar to what you have proposed in Colorado that would require all facilities to submit a periodic report of deviations?
No, because we tailored our proposal to the proposal that the department put forward in trying to acknowledge existing excess emission reporting requirements and trying to craft a proposal that seemed to harmonize better with what the department proposed. New Mexico's regulations are formatted and drafted differently than Colorado's in many regards. So we're trying to be mindful of that.
So I'm just trying to clarify what your direct testimony was. I believe you were asked whether the type of provision that you are proposing is common, and you said yes. Is that accurate? Do you believe it is common?
Yes, I believe emission reporting and deviation or excess emission reporting is common.
And are you testifying that it is common for all facilities, not just Title V sources, to have a requirement to submit periodic deviation reports?
I believe reporting requirements vary by the size of the source of air pollution. I don't disagree with that, and that sources subject to Title V are absolutely subject to more stringent reporting requirements. And that's why we tried to propose here a reporting provision that we felt would not be as stringent as Title V, but still assure that information regarding deviations is ultimately has a chance of becoming available to the public.
Well, let me just be clear the type of reports that I'm asking about. So I'm not asking about requirements to submit a report showing that monitoring was done, for example, or a report that obviously that monitoring is done. But you have proposed a requirement to submit deviation reports. And what I'm asking you is it your testimony that it is common for other jurisdictions to require all facilities, including minor sources, to submit reports of all deviations? Is that your testimony?
It's emission reporting is common. I'm not sure.
Yeah, I'm asking about deviation reporting. Is it your testimony that there are common requirements similar to what you have proposed for facilities to submit reports of all deviations at all facilities, including minor sources?
Well, we use the word deviations because there are a number of requirements in the proposed regs that don't relate to emission limits. There's no quantitative limit. Yeah, there's work practice standards or leak detection and repair. And so we wanted to make sure that monitoring events that detected exceedances, for lack of a better word, from those work practices or leak detection and repair, that they would be reported. The word deviations seemed like an appropriate term to use rather than excess emissions or excess whatever.
But just to bring it back to my question, you testified on direct testimony, as I understood it, that it is common for states to have provisions similar to yours, where you are proposing a requirement for all facilities to report all deviations. Is it your testimony that that is common? I'm not asking about emission reports or monitoring reports. I'm asking about deviation reports. Is it your testimony that the provision you have proposed commonly appears in other jurisdictions?
Madam Hearing Officer, I'm just going to object. This line of questioning has been asked, and it's my recollection that Mr. Nichols had responded to whether or not the reporting requirements are common in general in pollution control laws and rules.
Right, but I've heard Mr. Kolkleischer ask this very specific question now. This is his third time, and
Yes.
Mr. Nichols is very forthcoming. I can tell that he wants to answer the questions posed to him, but I don't think he's answered this question, whether other jurisdictions commonly require deviation reports.
If I understand, you're asking, is it common for other states to have a provision that is almost identical to what we've proposed here? Is that what I'm understanding?
As to deviation reports.
As to deviations, I don't know.
No further questions.
Thank you very much, Mr. Kolkleischer. Mr. Rose, I saw you next.
Thank you, Madam Hearing Officer. Just to be clear, I believe we're talking about Wild Earth Guardians Exhibit 1, and I wanted to question you on the draft language on your proposed addition subparagraph 11 to 20.2.50.112A. And I think that's the cause and contribute language that you were alluding to earlier with Mr. In response to questions. And I was looking at this and I was trying to understand how this differs. You're referencing part 72, 74, and 79, and how this differs from the language already in existence in those sections. And the thing that I could, that was apparent to me is that it looks like you've inserted a 95% of the primary NACs as a decision-making point, as opposed to the regulations talking about cause or contribute to violations exceedances of the NACs. So is that what you're intending to do, is to, in essence, make a 95% threshold here as opposed to 100%?
Yeah, thank you for that question, Mr. Rose. That's exactly what we're proposing.
And is that predicated on your understanding of the language in the state statute that gave rise or obligated the board to have a plan for ozone contamination?
Yes, it's predicated on the emphasis on preventing ozone concentrations from getting out of control, for lack of a better phrase, and keeping them definitively below unhealthy levels.
And I guess my question is more precise than that, is do you read the state statute as setting a threshold, a control level in essence reducing the standard to 95% as opposed to 100% or the next, which is what as I read this provision doing?
I guess I view what we proposed as fulfilling the overall duty for the board to adopt a plan to ensure ozone concentrations are reduced to below 95% of the ambient air quality standards.
That was my question. And is there a reason why Wild Earth Guardians hasn't proposed these changes in the regulations themselves as opposed to trying to do it in this set of regulations?
Well, that's a good question too. I think we saw these proposed regs as an opportunity to advance this concept. This is the first time the department has ever proposed a specific set of regulations to implement the statutory requirements to limit ozone concentrations. And so as kind of the first step, we thought it would be useful to put that concept out, but we would support that concept being embraced in other portions of the state's regulations. But that because of the emphasis on the oil and gas sector here as a major contributor to ozone, this seemed to make sense as a first step.
And I guess the question I had was, in terms of your consideration, this would only apply to specified oil and gas facilities, correct?
Yes, facilities subject to the regulations.
And so non-oil and gas facilities that were subject to permitting requirement under Part 72, Part 74, or Part 79 wouldn't have the reduced, the criteria would still be cause or contribute to a violation of the NAAQS as opposed to 95% of the NAAQS, correct?
Yeah, I guess we would view it as there would be two layers of criteria under which permits would be assessed. You know, that would be the practical outcome here.
And that's what I was trying to get at, trying to understand. And let's talk about general permit registrations. Are you, and I know there was some discussion earlier about Wild Earth Guardians challenges to a number of general permit registrations. I was curious, are you familiar with the general permit that issue in that case?
I am, and I just want to say I'm not sure how our permit appeals relate to what we proposed here. I'm just going to offer that and get that on the record. I think that they're very different issues, and what we're looking at is a regulatory proposal, and we're not dictating or prescribing how this should be implemented, other than this needs to be a threshold that is put in place.
And I'm not questioning that at this point. So I was more questioning sort of the net effect of what you're proposing. And the reason why I asked if you're familiar with general construction permits, are you aware that as a condition of the department issuing those permits, that they're subject to the language in Part 72, where the department evaluates whether a proposed source will cause or contribute to a violation of federal or state ambient air quality standards?
Yes.
So that as a predicate to issuance, as I understand the way the permits are written, there's actually a finding in the permits that they would not cause or contribute to a violation of the ambient air quality standards. Is that correct?
That's correct.
And so when a registration is submitted, it's my understanding that the only evaluation performed by the department is whether or not the proposed source meets the criteria. That is, it's the type of source for which the general permit's issued, correct?
Yes, that's correct.
And modeling is not a part of that review because compliance with the standards was addressed upon permit issuance before registrations would be submitted, correct?
Yes, that's correct.
And I'm trying to figure out how the department would make a decision if the only information in front of them was whether the source as proposed consisted of the units that would be eligible for a general permit. Is what you're asking them to do is to now attach another layer of review, that is, do modeling for those individual sources, or
again, we're not prescribing how this should be implemented. We're simply proposing a threshold. And if the department chooses to model, more power to them. We would support that. If they choose to take a more streamlined approach to assessing compliance with this threshold and making determinations around permits, then they can do that as well. I can't foresee, as it is right now, the department doesn't deny permits. At least from what we've seen, that may cause or contribute to violations, presumably because they've made a determination that sources aren't causing or contributing. I believe they'd be able to undertake a similar assessment here. But in the off chance that they do catch a source that may cause or contribute to ozone concentrations within 95% of the ambient air quality standards, then this provides them the mechanism to prevent that source of emissions and to protect the ambient air quality standards.
And I appreciate that. My point is that the time at which that decision is made for general construction permits is at the issuance of the permit itself. And that the point at which you should challenge whether or not the general permit causes or contributes to violations is when the department considers issuance of the general permit, not in whether a specific source meets the requirements, is eligible for the general permit. And so, I mean, those are things we can certainly look at in post-hearing submittals and debate. I think I understand what you're trying to accomplish, and we may differ as to whether it's accomplishable based on what you've proposed. So, Madam Hearing Officer, that concludes my questions of this witness.
Thank you very much, Mr. Rose. Ms. Sheehan?
Thank you, Madam Hearing Officer, and thank you, Mr. Nichols, for your testimony this afternoon. I just have a couple clarifying questions. Mr. Nichols, in your direct testimony, you refer to the excess emissions rule, which is found at 20.2.7 NMAC. Is that correct?
Yes.
And just for clarification, the excess emissions rule is independent from the proposed ozone precursor rule, correct?
It's in a separate section of the New Mexico Administrative Code.
Do you agree that under the existing excess emissions rule, the owner or operator of a source that has an emission or an air contaminant that is in excess of the quantity or concentration specified by an NMED rule or permit must report that excess emission to NMED?
Yes.
And would you also agree that under the provisions of the excess emission report, upon discovery of an excess emission report must be filed with NMED by the end of the next business day?
Yes.
So do you agree that every deviation that causes excess emissions must be reported under the excess emission rule within 1 business day after discovery?
No, it's not clear that the excess emission rule would require deviations from, say, work practice standards or even like leak detection and repair requirements, because those deviations don't necessarily correlate to a quantitative excess emission. And that's what we're trying to address here, is that the excess emissions rule, yes, it ensures prompt reporting on excess emissions, gets that information to the division or the department's hands, but that there's a lot of stuff in the proposed regs that doesn't necessarily impose quantitative emission limits. And the public needs to have a chance to understand whether or not those standards are being met or whether there may be deviations.
But just for clarification, any deviation that causes an excess emission under the reporting requirements of 20.2.7.110A1, those specific excess emission deviations, the requirements set forth under that regulation are to be reported to NMED within 1 business day.
Yes, and it's a very helpful and important excess emission reporting rule that's in place, and a lot of excess emissions get reported to the department, and then that data is made available to the public. And what we tried to do is maybe address a gap between the excess emission reporting and then reporting around deviations from, like I said, work practice standards or leak detection and repair, where you don't necessarily have a quantitative excess emission you can report. It was really like a deviation in the operation, and making sure that those instances, when those monitoring events are recorded, that they're provided to the department. And maybe in some cases they can quantify the excess emissions and they would be considered excess emissions. And so, yeah, absolutely, they would have to report them consistent with the excess emission reporting rule under 20.2.7. We just want to make sure there's that added layer of reporting required so that the public has a complete picture around a source's compliance status.
Thank you, Mr. Nichols. No further question, Madam Hearing Officer.
Thank you very much, Ms. Sheehan. Are there any other parties with a question of Mr. Nichols? All right, board members, we're going to have to save your questions for after the public comment. We really do need a break before we reach 5 p.m. Mr. Nichols, public comment starts at 5, but we'll continue with your examination after that. Let me tell you the names of the folks who reached out by email, and I will call you in this order. Senator Steinborn, David Boquin, Ellen Duake, Tara Lujan, and David Shoup. If I did not just read your name and you're on the platform to offer public comment, please reach out in the chat and I will call on you after I've called on the first 5. Thank you all very much. We will reconvene at 5 p.m.